ಈಗ crime register ಮಾಡಿದಾರಂತ.
The Thashildar has filed a complaint against me. Based on the complaint,
ಅದನ್ನ ಸ್ಟೇ ಮಾಡಿದೀನಲ್ಲ ನಾನು.
ಅದರ stay ಆಗಿದೆ. But it is
Wash ಮಾಡ್ಬೇಕು.
wash ಮಾಡಿ.
My submission.
I have submitted it.
Respondent, I appear for on behalf of respondent number 2 complaint.
Thashildar. Very good. Yes. 10 ಲಕ್ಷ ಕೇಳಲಿಲ್ವಾ?
I have never demanded.
Audio recording ಇದೆ sir.
He is not with somebody's.
ಇವ್ರು ಕೇಳಿಲ್ಲ ಬಿಟ್ಬಿಡಿ. ಯಾರಿಗೂ 10 ಲಕ್ಷ ಯಾಕೆ ಕೇಳಿದ್ರಿ?
Who is none other than his advocate. He is appeared.
Advocate 10 lakhs ಕೇಳಿದ್ರ?
ಅಲ್ಲ, ಅವರೇ ರೆಪ್ರೆಸೆಂಟ್ KT ನಲ್ಲಿ ಮ್ಯಾಟರ್ ಗಳಾಗ್ತಾ ಇದ್ರು. ಅವ್ರದ್ದು ಅಡ್ವೊಕೇಟ್.
ಏನಕ್ಕೆ ಕೇಳಿದ್ರಿ?
ಈ ಮ್ಯಾಟರ್ ಸಂಬಂಧ
ಯಾವ ಮ್ಯಾಟರ್? ತಹಶೀಲ್ದಾರ್ 10 ಲಕ್ಷ ತಂದ್ಕೊಡಿ ಅಂತ ಫೋನ್ ಅಲ್ಲಿ ಯಾಕೆ ಕೇಳಬೇಕು? Why should a Thashildar, a public servant, ask any person to give 10 lakhs?
Not in respect of.
ಏನ್ TDS ಕಟ್ ಮಾಡಿ ಚೆಕ್ ಅಲ್ಲಿ ಕೂಡ ಕೇಳಿದ್ರ? ಇಲ್ಲ, ಕ್ಯಾಶ್ ಕೂಡ ಕೇಳಿದಿರಾ?
Not in respect of this subject matter.
Maybe with respect of any subject, sir. Why did a Thashildar ask 10 lakhs to be given?
Lord,
And how has he gone on scot free till now?
Lord, one Umesh, he is the advocate of second respondent. He is filed applications before the KT and the transferring matter. He was retired, already retired.
ಸರಿ.
Lord,
Sir,
29/7.
ಈಗ ಈ ಕೇಸಲ್ಲಿ ಕೇಳಿಲ್ಲ. Audio recording transcript is very clear that 10 lakhs you have demanded. May not be from him. ಯಾರಿಂದ ಡಿಮಾಂಡ್ ಮಾಡಿರೋದು?
ಇಲ್ಲ, ಅವ್ರ ಹತ್ರನೂ ಮಾಡಿ.
Thashildar has to be Umesh.
ಉಮೇಶ್ ಯಾರು?
Umesh is advocate, own advocate.
Own advocate.
ಅಂದ್ರೆ
Own advocate.
second respondent
He is an advocate. He was appearing for Thashildar in the service matter, KT.
All right.
So therefore.
ಅಲ್ಲ, ಅಡ್ವೊಕೇಟ್ ತಹಶೀಲ್ದಾರ್ ಇಂದ 10 ಲಕ್ಷ ಫೀಸ್ ಕೇಳಿದ್ರೆ ಅರ್ಥ ಇದೆ. ತಹಶೀಲ್ದಾರ್ ಅಡ್ವೊಕೇಟ್ ಇಂದ 10 ಲಕ್ಷ ಯಾಕೆ ಕೇಳ್ತಾರೆ?
ನಾಟ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಸಬ್ಜೆಕ್ಟ್. ಅದು ಏನಕ್ಕೆ ಅಂತ
ಏನಕ್ಕೆ ಅಂತ ಅದೇ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಬೇಕು.
ಲೆಟ್ ದಮ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್. ವಾಟ್ ಹ್ಯಾಪನ್?
ನೀವು ಹೇಳ್ತಿರೋದು ಯುವರ್ ಓನ್ ಅಡ್ವೊಕೇಟ್ ಅಂತ. ಯುವರ್ ಓನ್ ಅಡ್ವೊಕೇಟ್ ಆಸ್ಕಿಂಗ್ ಫೀಸ್ ಆಫ್ 10 lakhs whether ತಹಶೀಲ್ದಾರ್ ಕೊಡ್ತಾರೋ ಬಿಡ್ತಾರೋ ಬೇರೆ. ಅಡ್ವೊಕೇಟ್ ಇಸ್ ಎಂಟೈಟಲ್ಡ್ ಟು ಆಸ್ಕ್.
ಈಸ್ ನಾಟ್ ಎನಿ ಫೋನ್ ಕಾಲ್ ಟು ಹಿಮ್. ಮಿಲಾಡ್
ಉಮೇಶ್ ಅಂತ ಮಾಡಿದಾರಾ?
ಅವ್ರ ಕ್ಲೈಂಟ್ ಮಾಡಿದಾರ. ಉಮೇಶ್ ಇಸ್ ಕಾಲ್ ಟು.
ಹೌದು ಸರ್, ಅದನ್ನೇ ಕೇಳ್ತಾರೆ. 10 ಲಕ್ಷ ಯಾಕೆ ಕೇಳಿದ್ರಿ?
ಏನು ಮೇ ಬಿ ಫೀಸ್ ಅದು ನಾಟ್ ಇನ್
ಫೀಸ್. ತಹಶೀಲ್ದಾರ್ ಯಾವಾಗಿಂದ ಫೀಸ್ ತಗೊಳಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರು?
Not in respect of this subject matter.
Whatever it is, when did Thashildar begin taking fees from clients?
After disposal of the appeal, he filed a complaint on 19th.
ಹೋಗ್ಲಿ ಬಿಡಿ, Thashildar ಯಾಕೆ ಕೇಳಿದ್ರು ಅದು ಕೇಳ್ತಿರೋದಷ್ಟೇ.
ಅಲ್ಲಿ ಇವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿಲ್ಲ. ಅದು ಹೆಂಗ್ ರೆಕಾರ್ಡ್?
ಯಾರಿಗೋ ಮಾಡಿದಿರಾ? ಮಾಡಿ 10 ಲಕ್ಷ ಕೇಳಿದ್ರೆ ಇಲ್ಲಿ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
ಮತ್ತೆ ಇವರು ಏನೋ ಮಾತಾಡಿದ್ದಾರೆ. I will not place that CD. ಇವರು ತುಂಬಾ ಮಾತಾಡಿದ್ದಾರೆ. ಅದನ್ನ ತುಂಬಾ ಎಂಬ್ರಾಸ್ಮೆಂಟ್ ಆಗುತ್ತೆ ಕೋರ್ಟ್ಗೆ. ಅದಕ್ಕೆ ನಾನು.
ಹೌದಾ? ಇದು ಕೊಡಿ.
ಅದೇನೇನೋ ಮಾತಾಡಿದ್ದಾರೆ. I will not place it.
ಏನೇನ್ ಮಾತಾಡಿದ್ರು?
Nothing. With respect to the transfer of Kata, that Umesh is my relative.
ಬೇರೆ ತರ ಏನೇ ಇದೆ. ಅದಕ್ಕೆ I will not place it. That one heard about.
ಬೇರೆ ಏನೇನು ಕೋರ್ಟ್ ಬಗ್ಗೆ ಎಲ್ಲ ಹೇಳಿದಾರಾ?
ಕೋರ್ಟ್ ಬಗ್ಗೆ ಎಲ್ಲ ಏನೇನೋ ಮಾತಾಡಿದ್ದಾರೆ. I will not place it.
ಮಾತಾಡಿ, ತೊಂದರೆ ಇಲ್ಲ. ಬಟ್ ಈ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದಾರಲ್ಲ,
ಇನ್ವೆಸ್ಟಿಗೇಷನ್
ಕೋಆಪರೇಟ್ ಮಾಡಿ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಅದ್ರ ಪಾಡ್ಗೆ ಅದಾಗುತ್ತೆ.
So far as this case is,
I will quash this.
Blood, that is only I objecting.
ಏನ್ ಹೇಳಿ?
Blood, 29/7/2024, one Nanjundappa sons is filed application for a transfer of revenue records. One Prasanna, as per annexure R2, Milord, Prasanna is filed statement of objections to objecting for transfer of Kata. Milord, then Thashildar initiated the proceedings, RRT proceedings. Then that proceedings, the advocate is petitioner is appeared. He asked for genealogical tree and other documents. He is objected for producing that. Milord, then Milord, 15/10/2024 order sheet speaks. He passed the orders saying that entire the property Kata was not rejected. Passed order in favor of the applicant, saying that property Kata to be registered. The family members of the he is objecting is that Milord, he want to register in one name. Against which that order, Milord, he filed appeal also before the assistant commissioner. Then Milord, after disposal, Milord, 18/10/2024, he want to advance the application. That only some
altercations have happened.
Then the Thashildhar has filed a complaint.
Ashana sir.
Yes.
When he has not received the complaint, he lodged the complaint before the Lokayukta saying that he demanding 10 lakhs.
Correct ಆಗಿ ಇದೆಯಲ್ಲ ಅದು?
After disposal.
Audio transcript ಇದೆ.
After disposal of the
prepaid or postpaid ಒಟ್ನಲ್ಲಿ ಕೇಳಿದ್ದೆ. ಹೌದು.
No date, time, nothing, Milord. Let them investigate the matter, Milord.
ನಿಮ್ದು ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡ್ಲೇಬೇಕು.
ನಮ್ದು ಮಾಡ್ಲಿ,
ಅವ್ರದ್ದು ಯಾಕೆ ಮಾಡ್ಬೇಕು? 353 is the allegation. ಏನ್ ಬೈದ್ಬಿಟ್ರ ಇವ್ರು ನಿಮ್ಗೆ?
ಗಲಾಟೆ ಮಾಡಿದ್ದಾರೆ ಅವತ್ತು ರಚನೆ.
ನೀವು 10 ಲಕ್ಷ ಕೇಳಿದ್ದು ಗಲಾಟೆ ಮಾಡ್ಲೇಬೇಕು.
ಅವ್ರು ಕೇಳಿಲ್ಲ. ಅವರು
Anything else? Yes. The petitioner, a practicing advocate appearing in person, is before the doors of this court, calling in question the registration of a crime in crime number 223 of 2024, registered for offences punishable under section 132 of the B&S, which is 353 of the earlier regime, the IPC. Facts in brief, but germane, are as follows. The second respondent is the complainant. The petitioner, the second respondent, the Thashildar,
Ajjampura.
Ajampura,
Ajjampura Taluk
hello.
is the complainant in the case at hand. The petitioner appears before the Thashildar seeking mutation of kata in favor of the legal representatives of his client. It transpires at that point in time, there are certain altercations between the petitioner and the Thashildar. The Thashildar passes an order against which the petitioner is said to have preferred an appeal. Appeal is in your favor?
Appeal is set, that Thashildar order is set aside and remanded back to
The appellate authority, the assistant commissioner,
Assistant.
sets aside the order of the Thashildar and remits the matter back to the hands of the Thashildar for consideration of fresh of the claim of the petitioner's clients, After the said remand, the petitioner registers a complaint before the Karnataka Lokayukta with certain evidence of conversation recorded in a compact disc to the Lokayukta, recorded in a compact disc, alleging that the second respondent Thashildar had demanded Rs.10 lakhs as alleged bribe, not from the petitioner but from one Umesh. The recording was not taken to its logical conclusion, nor a crime was registered against the Thashildar. In turn, the crime was registered against the petitioner for alleging that the petitioner has raised his voice or has abused the Thashildar who was performing his public duty at the point in time. And therefore, the complaint becomes a crime in crime number 223 of 2024 for offence punishable under section 132 of the B&S 2023. It is at that juncture the petitioner is at the doors of this court calling in question the registration of a crime in crime number 223 of 2024. The petitioner in person would contend that the Thashildar has registered the subject complaint as a counterblast to the complaint so registered by the petitioner before the Lokayukta, which had not yet resulted in registration of a crime. He would submit that none of the ingredients as is necessary in law, as laid down by the apex court in several judgments, is met in the case at hand insofar as it concerns the offence under section 132 of the BNS 353 of the IPC. Per contra, the counsel appearing for the second respondent complainant, the Thashildar, would submit that the petitioner has in fact hurled abuse upon the Thashildar at the time when he had visited him for preponement of the case after the remand from the appellate authority.
After disposal.
The Thashildar dispose ಮಾಡಿದ್ರು.
Our dispose ಆದ್ಮೇಲೆ he filed a complaint.
After the disposal of the proceedings before the Thashildar, he would submit that it's a matter of investigation, and the investigation, the court should not, in exercise of its jurisdiction under 482 of the CRPC, interfere at this stage of the proceedings. The learned additional SPP, B. and Jagdish, would also submit that the matter is still at the stage of investigation, and therefore this court should not interfere with the said proceeding. I have given my anxious consideration to the submissions also. The afore narrated facts, link in the chain of events, and the dates are all a matter of record. What drives the petitioner to the Lokayukta is the complaint so registered by him. The complaint
Annexure C page.
Complaint registered by him, Annexure C, page 18. The complaint in the narration in the complaint is that the Thashildar has hurled abuses and has demanded money. The Lokayukta does not take any action. In turn, the Thashildar registers a complaint on 19/10/2024 against the petitioner for alleging that the petitioner has spoken in loud voice and abused in the chamber of the Thashildar. In the chamber of the Thashildar. So, Thashildar, therefore, it becomes a crime in crime number 223 of 2024. The issue now would be whether the complaint so registered, the complaint so registered by the Thashildar, the complaint reads as follows, 19/10/24 reads as follows, page 12. The complaint so registered by the Thashildar would meet the ingredients of section 353 of the IPC/132 of the BNS. Section 353 of the IPC directs or punishes a person who would stop a public servant from performance of his duties by use of criminal force or assault, as the case would be. Section 349 to 351 define what is assault and what is criminal force. If the ingredients as is found in section 349 and 351 are noticed, none of those are present in the complaint so registered against the petitioner. It would, therefore, it would not become an offence under section 353 of the IPC or 132 of the BNS, Permitting further proceedings against the petitioner would be permitting a complaint that is registered as a counterblast to what the petitioner had registered against the Thashildar before the Lokayukta. The apex court in the case of Bhajan Lal was, State of Haryana was Bhajan Lal, 1990, para 102 extract has laid down 7 postulates of entertainment of a petition at the stage of crime and exercise of jurisdiction under section 482/528 of the BNS. In the light of the law so laid down by the apex court in Bhajan Lal as the apex court considering what would be the purport of section 349, 351 and 353 of the IPC has in SLP 5905 of 2022 disposed on 21/10/2024 in the case of KV Dhananjay versus State of Karnataka has held as follows. So paragraphs held in the light of the law laid down by the apex court in the case of KV Dhananjay versus State of Karnataka, which applies to the facts of the case at hand on all its force, FOURS, on all its force, permitting further proceedings would become an abuse of the process of the law. It would become apposite APPO, apposite to refer to the judgment of the apex court in the case of State of Haryana versus Bhajan Lal. So in para 102 clause 157 highlight madi. In the light of the aforesaid judgments, the apex court, I deem it appropriate to exercise jurisdiction under 482 of the CRPC and obliterate the crime against the petitioner for the aforesaid reasons allowed cost. Yes.